Hello, my name is Marian Lippa, and I'm a candidate for the Paralegal Standing Committee. Many of you know me from lecturing at the colleges, CPD programs, or seeing me in court. And many of you know me from my recent action before the Superior Court of Justice regarding the Barristers Act and its effect on paralegals in the criminal court. This action drew attention to this unfair practice, and the entire legal community took notice, as well as our governing bodies. My action is an example of my tenacity and passion for this profession. I believe that my colleagues know that I will not back down. However, I realize the need to be conciliatory when it's necessary. Over the years, I've had many lasting relationships with lawyers. I realize that as a standing committee member and bencher, it is important that I bridge the gap between my paralegal and lawyer colleagues, because there is only one legal profession and we must all advance the interest of access to justice. There are still a lot of statutes and regulations that are in need of amendments. I will work hard to ensure that they are amended to reflect paralegals' role in the legal profession and to ensure that paralegals get the respect they deserve. Prior to regulation, paralegals provided many services that they no longer are allowed to provide. I will work with my standing committee colleagues in convocation to bring back some of these services. In my tenure of 20 years in the legal industry, I was previously employed as a law clerk. My training and education was under the Institute of Law Clerks of Ontario. There, I was educated and tested with the Bar Ad materials, the same ones used by the lawyers, to ensure my competency and skill set in the areas of family, corporate, estate, and real estate law. A valuable education that served me well. I believe we can implement this standard of education using this model for those who wish to expand their scope of practice into these areas that we no longer service. Once these additional education components are put in place, that graduate will receive specialized licensing in order to practice in the expanded area. After all, should we not be educated the same if we are going to practice in the same areas of law as the lawyers? How can we measure up in competency without comparable education? It is important that we get these areas of practice back, as there has never been a greater need for access to justice for the public than today. An alternative, more economical legal provider for lower court matters. But we can only do so with proper educational standards in place, together with stringent testing to ensure competency. Yes, education has been on the forefront of everyone's mind, and our current model has suffered some high criticism from ourselves as well as the legal community. I believe that increasing the length of instruction to allow for a deeper understanding of legal theory at the college level, as well as expanding the educational school choice to include more university degree programs, will be critical to the success of future generations of paralegals. Legal theory and the application of it is neither easy nor can be accelerated. For those who don't have an underlying university or college degree before entering the college program, the one-year program can prove quite difficult to grasp and provide the confidence one needs to practice. My goal is to create a standard of education that will give us the ability to compete at the same level of competency in areas of law which we share in common with the lawyers. With the licensing exam now changing in 2015 to include substantive law, it is critical that the college's programs are up to par. I will work with the Law Society to increase articling hours to ensure students are given real and practical hands-on experience so that they have the skill set they need to be successful. To do this, I will seek to provide incentives to employers to take on students, perhaps granting professional CPD hours instead of just substantive. I also believe we should be limiting those principal employers who provide articling to the students to possess a minimum of 3 years of experience to give the students the most benefit at their co-op. In the area of immigration, there is a gap that must be filled when it comes to immigration practice areas for paralegals. The difference lies within the permissible practice areas afforded under our federal legislation, but restricts us under the provincial regulation. Many are required to hold 2 licenses, double the insurance, and be qualified under 2 different licensing bodies. This has to change. These are just some of the obstacles our profession faces. Join your paralegal associations to ensure we speak with one voice. There is strength in numbers. There must be transparency between the Paralegal Standing Committee and the paralegal associations so that issues can be raised and heard. With your vote, I can be your voice. Thank you.